The previous material was written before the Supreme Court struck down the federal government's Defense of Marriage Act. This has had wide-ranging consequences on state and local laws as well. Since this is such an important and controversial topic, I wanted to address it as part of this course. As you can see from the map, all of the blue states now recognize same-sex marriages. In the gray states, district courts have ruled those laws prohibiting same-sex marriages unconstitutional, and those decisions are now awaiting a Supreme Court appeal. In the brown states, the local laws have been challenged, but no court opinions have been rendered. Only in North Dakota have the laws prohibiting same-sex marriages remained unchallenged. Now let me start by debunking a popular myth. Just because the law recognizes same-sex marriages in your state, you cannot be required to perform one. The First Amendment to the Constitution allows you to protect and defend and practice your religious beliefs. If it offends your religious beliefs to perform a same-sex marriage, the law cannot require you to perform one. There have been recent examples of this. A Mississippi pastor, for example, refused to marry a black couple after some members of the church objected. A Houston pastor refused to marry a couple because he found the bride's dress offensively sexy. Now, although we may question the wisdom of these decisions, the Constitution gave the pastors in question the right to make those decisions. The same is true of your wedding ministry. Let me give you another example. Personally, I would not perform a wedding without premarital counseling. Let's say the couple shows up for their premarital counseling and the bride-to-be has a black eye and her arm is in a sling. I could refuse to marry that couple because I do not believe in abusive relationships, and the Constitution gives me every right to have that belief and enforce it in my ministry. The same is true of your ministry. If you find same-sex marriages to be morally objectionable, no law can force you to perform one, and no court would find against you if the couple decided to file a lawsuit. In fact, you might be entitled to file a countersuit for frivolous litigation. So if you want to perform same-sex marriages and your state's laws allow you to do so, then by all means do so. If you find such unions morally objectionable, however, you are under no obligation to perform them, even if your state's laws allow it. Now, the government cannot control who you love or who you sleep with. The laws prohibiting homosexual conduct were overturned by the Supreme Court in the case of Lawrence versus Texas in 2003. The government can, however, control who has access to government programs and benefits. A study by the Government Accounting Office found that the federal government grants to married couples over 1,100 benefits. You can find a list of those benefits, which runs about 75 pages, at the link shown here. Many companies also offer special benefits to employees who are married. Again, that only applies to those who are legally married. Civil unions and other such arrangements don't count. To me, this is another example of states trying to be separate but equal, which of course was the basis for the historic Brown versus Board of Education case back in 1957. But again, you are free to conduct your wedding ministry according to the tenets of your religious beliefs. So, if you want to perform a civil union ceremony, a hand fasting, a renewal of private vows, or other such ceremony, then by all means do so. You should, however, be sure to inform the couple that this ceremony will not affect their eligibility for government or employer benefits. Now let's continue with our discussion of how you are going to establish your wedding ministry.